Hello and welcome. My name is Shiloh Daum. I'm an eminent domain lawyer with the law firm of Seaver, Story, Walker, and I'm here to talk with you tonight about the Ridgeline and Cumberland pipeline projects in central and western Tennessee. I'm here at the following some letters that we sent to landowners throughout the state who are potentially affected by this pipeline project. And I hope that you have come to try to gather some information, get a better understanding of the project, and to learn a bit more about the process that you may be facing as a property owner impacted by a utility line such as this. I'm going to jump right into things. If you have a question, I invite you to put it in the chat or to reach out to me directly, either by telephone or email. We can have an individualized consultation at a time of your convenience. I'm going to jump right in. Give me a moment to share my screen, please. Again, this is we're going to be talking tonight about the Tennessee Ridgeline and Cumberland gas projects. These are two different projects, one in west central and central Tennessee, and the other maybe more in eastern Tennessee, I suppose you would say. But ultimately, I'm going to try to give you some information that is equally relevant to both of those projects. Tell you a little bit about what I'm going to talk about. I expect typically I'll talk for 45 minutes or so, plus or minus a few minutes. And tell you about who we are, who we're not, information about the project, essentials to understand about the eminent domain and condemnation process, how compensation is determined, things of that nature, what you want to do and don't want to do as you move forward and begin this journey. Just a couple of disclaimers, and so you know who you are hearing from. We are an independent national law firm. We are a litigation boutique firm focused exclusively on eminent domain issues on behalf of landowners. We work in the Midwest and Mid-South and throughout the country on pipelines, power lines, road projects of various types. We don't have any connection to the TVA, to Tennessee Gas Pipeline, Kinder Morgan, Enbridge, or FERC, which is the Federal Energy Regulatory Commission, the government body that regulates most of these issues. We're not affiliated with any of these companies. We don't do work on behalf of any condemning authorities, government or agencies or utilities, nor are we working on behalf of any opposition groups, environmental groups, or some of the folks who may be working to oppose the pipeline. And I'll talk a little bit more about that later as well. Lastly, the advice that we give you here and my explanations are general in nature and do not create an attorney-client relationship. If you want individualized consultation or valuation representation, we'll document that with a written retainer agreement. I just want to introduce you a little bit again about our firm. As I indicated, we are a boutique firm practicing in a narrow niche of law. Not everybody does what we do, and there are other people out there who do it, but they tend to be specialized, much like our firm is. You're not just hearing from me tonight, though. I'm bringing to you my specific area of expertise and knowledge, but you have collectively over a century worth of combined legal knowledge and experience in representing landowners of every type, from an individual property owner defending their house to large national corporations protecting their business interests and their business properties. We've handled hundreds and hundreds of property rights cases on behalf of these landowners facing pipeline, power line, all kinds of utility infrastructure, as well as public works and road projects. Our focus is representing these property owners to make sure that they get treated as fairly as possible and that they be compensated fairly and reasonably for the whole scope of losses they're facing being caused by a particular project. All of my contact information appears on the screen before you, both my personal email, my direct telephone line, as well as the main line into our law firm. So if you're not able to speak with me, you're always welcome to talk with one of my colleagues, and any one of us will be happy to help. Our law firm mission, and the reason I'm here with you tonight, is to make sure that you have as much knowledge as is possible. In my line of work, information is currency and knowledge is power. And we want to make sure that landowners make the best decision possible, knowing all the facts, having a good solid understanding of what the law does and doesn't allow, And we want to make sure that your rights are protected. The worst thing that I hate to find out is that I talked to a landowner, and I had this happen a little bit earlier this month. A landowner I talked to said, "Oh, I wish I had talked to you earlier. My brother went ahead and signed a deal, and he cost himself literally hundreds of thousands of dollars." Those kinds of stories really drive my decision making, and it's really our mission to make sure that we get the word out and make sure that you are empowered so that you understand what's at stake and how you can best position yourself moving forward. I want to make sure that landowners are more on an equal footing with powerful corporations, utility companies, and the governments that make a lot of these decisions. You only have one chance to get this right. A landowner who makes a decision today will impact the land that they're on for generations to come. These are permanent rights that are at stake. And so you have to make sure that you do the job knowing what's involved. A little bit about my background. This is the first thing I ever learned about eminent domain. It came from Bugs Bunny. And whether I realized it at the time or not, it was really kind of a formative idea that was implanted. I knew that people had to, whether they were building a road or working on a project, that somebody's land had to be involved, and sometimes somebody was displaced. In this case, this great little sort of nostalgic cartoon reminds me that it's sometimes possible to stop or move a project. Whether it's a good idea is an entirely different matter. And I want to start from the very outset and tackle the question of, can you stop these projects? And I'll get to that in a moment. The one thing I do want to tell you is that in this case, essentially, it is very difficult to stop a project that has already been approved, or one is quite far down the regulatory path toward approval. The amount of time and financial resources that are required to go into that can be exorbitant, and really it requires advocacy early and often. I know that there are a number of groups involved in and around throughout Tennessee who are actively opposing some of these pipeline projects. If you want to try to lobby and prevent your legal rights from being taken away, consider being a part of those organizations and those groups. That said, I'm going to talk to you tonight based on the assumption and the presumption that this project is moving forward, and that is likely to impact you sometime in the next few months or years. Going back to the Bugs Bunny cartoon, though, one of the things that is really important to understand is you can wind up finding yourself being in what I refer to as sometimes the worst possible situation. In this slide, you see sort of the best and the worst of both worlds. He won supposedly by getting the highway moved and preserving his little rabbit hole. But the worst possible place to be on any project is actually the person who is not physically touched by the project, but who still has to live with all the headaches and the disadvantages of it. But those are people who may not actually get paid a penny for their trouble. And so we'll talk a little bit about how you can potentially avoid that. Overview about this project and the two combined projects, rather. In essence, the TVA is replacing 2 coal-fired power plants with natural gas-fired power plants. And they are going to need the supply infrastructure pipelines feeding those gas power plants in order to achieve that goal. I understand a lot of people, again, with regard to advocacy, feel strongly about energy issues, about the balance of renewables versus conventional fossil fuels and those kinds of things. I'm not really going to focus on the particular politics of it all. What I am interested in right now is the practicalities and how it affects your pocketbook and your legal positioning. I want to maximize that regardless of how people feel, and we can build a unified sense of community, hopefully, in trying to make sure that no matter the ultimate outcome, that everyone has their rights protected to the maximum extent possible. This slide illustrates the Cumberland Project in the western third, roughly, of Tennessee. And this is the shorter of the two projects. And again, natural gas pipeline going to tie into some other infrastructure to feed a new gas plant operated by TVA. The Ridgeline expansion project, similarly, in the eastern third of the state, is focused on providing, it's a bit longer, it's nearly 3 or 4 times as long, and parallels an existing pipeline corridor to feed the TVA facility in Kingston, just west of Knoxville and not far from Oak Ridge. The Cumberland Project's 30 so miles, 30-inch diameter pipeline with some other lateral lines that it connects to. It's going to have some pressure facilities, some metering stations, some other valve control stations. There'll be things, an inspection points called pig launchers or pig traps. Those are essentially above ground valve control devices. They look like pipes literally coming out of the ground, and those are part of the inspection and maintenance facilities that these pipelines have. But the vast majority of these pipelines are going to be several feet underground, nearly 3 feet in diameter. 80% of this Cumberland pipeline is adjacent to an existing right-of-way, or it's within very close proximity to an existing power line transmission right-of-way. This and both projects are an example we call co-location. Now, I am not an engineer, I'm a lawyer, not a civil planner. But what tends to happen in cases like this is that we have pre-existing infrastructure, pipelines, and power lines. They tend to try to consolidate those because the thinking is that the damage to the property is not as impactful as if you're taking it across, for example, previously untouched forest, or forest agriculture, or other types of communities. The Cumberland Project has an approximate 100-foot right-of-way. It may ultimately be reduced to a total of 50 feet in the right-of-way. It's not clear as to whether or not the 100-foot right-of-way is the permanent right-of-way or includes some temporary space. But it will involve 3 new permanent access roads, about a half a mile almost of new power lines near one of the metering stations, and is expected to begin construction potentially as later this year. I'm taking that rather skeptically, given the timeline. The Federal Energy Regulatory Commission only granted them their certificate of public convenience and necessity, which is the magic document that they have to have in order to move forward and go forward developing the project, acquiring rights, and beginning to build it. They got their green light just earlier this year. Just last month, environmental groups filed a lawsuit to begin to challenge the FERC's decision in this to give them the green light. If I had to give a forecast, I would expect that eventually, if not in the near term, that this project would be able to overcome any of those legal challenges and should be expected to move forward. And that's, again, the presumption that I'm utilizing going as we talk about things tonight. The East Tennessee Ridgeline project is a much larger, over 120 miles, similar size pipeline. It's got a small lead-in section, a small header section, and then the main line, about 118 miles. It's going to have a single large compressor station that will be partially powered by a solar array, and then additional metering stations, again, scattered throughout. Interestingly, this pipeline is also going to have linkages with 2 other pipelines. So they basically create a feeder that goes into the main trunk, which will ultimately go over toward Knoxville at Kingston. Like Cumberland, the Ridgeline pipeline parallels an existing line along the vast majority of its route. So essentially what we're going to be doing is putting one new pipeline next to an existing one, or maybe an old, retired, or out of service line. They are going to be removing some previously abandoned pipe and putting new pipe in the same trench. If you're somebody in those circumstances, it is very possible that you may not be entitled to any new compensation, because earlier utilities might have included the rights for the power line or pipeline companies to be able to do just this, take this step. The temporary and permanent rights of way are going to be up to 150 feet wide, and additional workspace. There's going to be multiple staging areas, these contractor yards, and dozens and dozens of access roads. So this is a much more intensive in terms of larger project scale of the two. Again, the permanent easement tends to be about 50 feet wide when everything is said and done. And in a couple of select locations, it might skinny down, particularly where it has crossed some of the water courses. This project, they anticipate to begin later next year, so a little over a year from now, and to have gas actually flowing in the following fall in 2026. The Ridgeline project just had the draft environmental impact statement issued this past week. And in that, the FERC, the federal agency, concluded that there was not going to be significant adverse environmental impacts, suggesting to me again that this project is very well on its way to also receiving its final and full approval from the federal government. These are pictures of what the projects typically look like in development, what the pipeline trenching and pipe laying process looks like on the left. And on the right, this is a typical representative picture of what a final gas easement looks like after some time in service, once the grass and the restoration has been fully complete. This is technically a picture, I think, from another gas project I did in southwestern Virginia. So very, very similar terrain to Florida, especially eastern Tennessee. The legal foundations are important to understand. The Constitution of the United States, as well as the state of Tennessee, generally provides for the right of public use to acquire private property. That's fundamentally what we talk about and what we mean when we discuss eminent domain or condemnation. Eminent domain is the legal power. Condemnation is the specific type of lawsuit, but the terms are essentially interchangeable from a landowner's perspective. Under the Natural Gas Act, a federal statute enacted darn near a century ago now, the federal government authorizes private pipeline companies to have eminent domain powers after they've received regulatory approval from FERC, and allows them to take property rights from a private landowner. They do this most typically in the nature of an easement. The pipeline companies will approach an owner and say, we need to acquire an easement. Now, you as a property owner typically own your land in what's called in fee simple, meaning you own all the rights to the land. And when they seek an easement is a right to use, but not necessarily actually own outright a piece of land. Now, as a practical matter, an easement may convey and involve nearly all the practical and meaningful elements of ownership that are comparable to a fee ownership. They can, for example, an easement holder can prevent the fee owner from disturbing or interfering with their use. So that is why they're not going to allow any what are referred to as encumbrances or encroachments. You cannot build structures largely on top of their easement areas, because at any time they may want to be able to exercise their right to inspect, maintain, replace, or otherwise work on that land to operate and undertake activity related to the pipeline purposes. So it is really important to understand an easement. But to simplify things, the easement gives you as the underlying landowner sort of very limited rights to afterward. You have the ability to pass over and utilize the surface land, but only in a way that doesn't potentially that they don't object to. Practically speaking, that means you can grow grass and you can mow grass and you get to pay the taxes on it. But there's not a whole lot else that you can do with the area under the pipeline easement. You can oftentimes put driveways and crossings. You can sometimes under certain circumstances have fence lines, but even those have to be spelled out and are oftentimes subject to the pipeline's approval and willingness to allow you to do that. What's going to happen is at some point, either already or very soon, land agents working on behalf of the utility company, the pipeline folks, are going to reach out to you and begin to make first contact. They possibly and probably already had repeated contact with you, telling you, notifying you about public meetings, information sessions, and basically trying to build some goodwill in the community, so that they aren't seen as interlopers and folks who are out to take advantage of folks. One of the things that they may want to request either now or already is survey access. As a general rule, it's surveying is something that they're allowed to do, and something that, if necessary, they can go and seek court approval for. But generally speaking, I don't advise folks that that they spend too much time trying to have the fight over survey issues. Really, they should conserve their energy and resources for other much more important, substantial, and substantive areas of law. At some point, they're going to make begin preliminary negotiations with landowners, and they're going to say, we need to come and acquire a certain portion of your land. Let's say we need an acre upon which to put this pipeline, and we're going to traverse your land. We're going to undertake an appraisal and make you an offer. Now, that appraisal or offer may or may not be based in specific value related to your land. They will oftentimes simply have a professional appraiser that they hire who will kind of go on a countywide basis and say, well, here in this county in Tennessee, land is worth X dollars an acre. And from that, they will come up with some sort of calculation and number to give you as part of a proposal. And then they will put a very thick easement document in front of you and say, we'd like you to sign this offer. Okay. The things that are in that easement are what are definitive and controlling. Nothing that land agent tells you makes, as far as an oral promise to you, has anything to do with what your actual legal rights are and what you're potentially signing off on. The terms of the easement are absolute and controlling. They are a contract. They are like a deed. They convey a certain rights in that land, and they do so permanently. There are many, many terms of these easements. They were going to go on for dozens of pages, and they're going to contemplate all kinds of uses and limitations on you as a landowner. You have to be careful about and understand what it is that you're signing and what you're giving up and what you're not. One of the things, and where a lot of our time and energy is spent, is in two places: is negotiating the right and proper scope in terms of those easements, and then the other thing is the issue of just compensation. Again, I told you about the legal foundations. The Constitution says property owners can have their property taken from them for a public use, but if you're going to do that, you do have to pay them fair and just compensation. That just compensation is based on the fair market value of the property that they are taking. And that will include any improvements that they think. So if you have a barn, a shed, fencing, even something like gravel driveways, those are considered improvements as a term of art in my field. Something that it may also include is something that's referred to as severance or remainder damages. Those are not the damages to the area that are between the lines of the that they're actually taking, but what it refers to is the damage to the property that's still remained and owned by you and unencumbered by the easement, but it is still adversely impacted from a valuation. Imagine a scenario where you have a house, and your house is right next to a pipeline or a power line. Obviously, we all sort of intuitively recognize that house is going to be looked at as being less desirable and less valuable by a lot of potential buyers in the marketplace because of the pipeline that's right there, and because of the proximity of an unsightly or undesirable thing of industrial equipment like that. The correct value and measure of damages in an eminent domain or condemnation action is what is the difference between the property before the project versus the property after the project. That difference, that is the amount, and essentially, in a nutshell, the measure of just compensation. And additionally, there can be what's considered cost to cure. Say, for example, they take out, in the scenario I gave you a moment ago, they take out your septic field or your well, and you have to pay to relocate that. Those are what are referred to as cost to cure damages that can also be a part of it. An important idea to understand too in terms of just compensation is you're entitled to the value of your land based on the highest and best use of your land, meaning what is the most maximally productive and economically advantageous use of your land, not necessarily based on what it is today. Let me give you, I'll come back to that concept in just a few minutes. Valuation and the assessment and appraisal process is typically based on one of three approaches: the sales approach, the income approach, and the replacement value. And there's a number of issues that you have to be attentive to. A lot of us have seen appraisals. If you've ever had bought or sold a house, if you have ever refinanced a mortgage or anything like that, typically speaking, you're going to get an appraisal. Now, the appraisals that you might see in those scenarios, maybe they're 3, 5, 10 pages at most, and they look at comparable sales. That's really easy to do with a primary single family residence, but it's much, much harder to do with other properties that are a little less susceptible to a direct kind of apples to apples comparison. For those kind of properties, or for commercial income revenue producing properties, they're going to do an income approach. So if you have a storage facility, a self-storage facility, it's worth a lot more than just the dirt that it's sitting on, because it generates a steady stream of revenue and income to that property owner. If you can't utilize a piece of property for its full maximum revenue production anymore because of a taking, then the income approach could be important. And then the replacement valuation model is more for unusual properties, and oftentimes, again, you're going to have costs to cure. Say they have to take a church. Churches aren't bought and sold very widely every day. They're not the kind of thing that has really well-developed market. And so if you are a church and you're having a portion of your sanctuary taken, you have to rebuild one, you're going to look more at the replacement value as a way to measure value and what you're entitled to recover. At the risk of being too cautionary, or I don't want to alarm anybody, but I do want to make sure that you understand that anytime you're talking to a land agent, to a right-of-way agent who's been hired by a pipeline or utility company, that they are there and they are not on their side. They are working for somebody else who pays them and in fact gives them bonuses to acquire property from landowners. All right. And they will oftentimes play a type of shell game. They want to focus your attention. They're going to come to you and they say, owner, your land is worth, in this part of the world, is worth $10,000 an acre, and we're taking 1 acre, so we're going to give you $10,000, but we're going to discount a little bit because you actually still technically own it. That's what I was talking about earlier, the difference between fee ownership and an easement. So maybe we're going to pay you 80% of the full value of the 1 acre that we're taking from you, and that should be good enough. Understand that their job is to get as many folks to sign on the dotted line as possible. Their sole focus is to make sure they complete the project on time and under budget. They have got to make their numbers. Just like any other salespeople, they will sweet talk and slick talk you as much as they possibly can in order to make you do what they need you to do, which is to sign those land rights away. You have to understand that all the things that they're potentially putting in the easement language aren't necessarily things that they're absolutely entitled to. Some of them, the federal government and regulations will potentially allow for them, and some easement terms aren't even things that we can negotiate away. That said, they are going to try to slip things past you that and maybe sometimes even misrepresent what's in the nature of an easement. As I said, it doesn't matter what they tell you, it only matters what's written in those documents. One of the things that they will do is they may say, well, this is more or less, something approximating tax value. Tax value has no bearing on fair market value and these kind of things. And in fact, under the rules of court, the tax value is not even admissible in any legal proceeding in these kinds of cases. They may say, well, guess what? We'll offer you a little bit extra in crop damages if you're in agriculture or something like that. Ultimately, what they want to do is they want to divert your attention away from sort of the core issue and the correct measure of damages, which is what is the fair market value of the property before and after. You have to look at it in that holistic context. You have to look at all the impacts that the easement will have to the property now and going forward in time. And that's a really, really important perspective that you as landowner should and and be prepared to understand. As I said a few moments ago, highest and best use of a property for a lot of the property that these pipelines are going to be crossing is fairly undeveloped. It's very rural in character, and quite picturesque, of course. That's exactly the kind of community I live in here in North Carolina, just across the border, and where I have other property in far western North Carolina. But the highest and best use of a property isn't currently how it's being used. It's potentially the highest use that could be used for that is reasonably probable, legal, physically achievable, and financially feasible. So we all are sort of familiar with a piece of a farm, for example, that was historically owned, but maybe is being is desirable now for commercial development or for residential development. You don't value that as a farm. You value it based on its development possibilities as a future shopping center, for example. That's a change in highest and best use that a land agent is never ever going to want you to be aware of or to be talking about. Again, it's not necessarily what's been before, it's what it can be. Now, it can't be totally pie in the sky. You can't just make something up out of whole cloth. It has to be grounded in reality. But that's part of what we can do, is to help landowners make sure that they understand how to make an effective argument for highest and best use for their property. Here's an example. This is a piece of property. This is actually these yellow lines illustrate the outer edges of a pipeline corridor. The shaded area on the left side of the screen illustrates an area the actual pipeline was going to go. And this is adjacent to a development, a very high value residential development. These pieces of property currently zoned and previously zoned and planned for were agricultural, rural, woodland, but it was adjacent to a growing metropolitan area, and very, very high value, large custom homes were being built, as you can see in the center bottom of the screen. And the pipeline, presence of the pipeline essentially destroyed the viability of multiple potential home building sites. That's an example of a change in highest and best use. This property is never going to be able to have homes on it anymore. And that developer was entitled to be paid a lot more than the pipeline was potentially offering. You have to understand as well, when you're developing your arguments and trying to build your case for compensation, that you have to have the right experts and the right knowledge base. This is an example. If you imagine that you were a farmer and you were still actively working the land, and you had a pipeline or a utility line that was crossing it. Just the mere change in the shape and the particular location of a property can have of a easement on a property can have a substantial and measurable impact to the marketability and the ultimate sales price. A couple of vital facts, frequent questions that you might have. Do you have to take their offer? No, you don't have to take their initial offer. And I'll come back to some additional guidance on this issue. You have the right to fair and just compensation based on market evidence and what can be established and proven. They're not the only side that gets to unilaterally decide how much your property is worth. You can fight for more, and you very well should. Let's talk about what happens when you do fight. That is essentially the process that you're potentially facing. And ultimately, if you're not able to negotiate or reach a satisfactory agreement with the utility company for the value of the land that they're taking, you do potentially face condemnation or an eminent domain taking. That's the legal process where they actually file a lawsuit and acquire your property sort of against your will. They are still required to pay you for it, and that's where some of the issues in terms of valuation that we've been talking about still have to be worked out and ultimately potentially settled in a courthouse. They are also required to follow a number of different procedural steps during the process of leading up to and ultimately acquiring your land, if they actually do have to go through condemnation process. It is really important to understand that in the course of a case like this, over the course of the next year or years, you might encounter several different multiple offers from land agents. They will utilize things like time pressure. They will say, "Oh, well, if you don't," will threaten you with a lawsuit, and that's okay. That's something that might ultimately be on the horizon. But you have to understand when the best times and the maximum amount of leverage that you have as landowner to get the best possible deal. If you do find yourself in a situation where you can no longer stop or divert the taking and otherwise are going to have to live with this project. Don't fall prey to the time pressures, or the artificial time pressures, I might say, and the sense of urgency that a land agent will bring to you. They will make you believe that, if you don't sign today, that the world is going to end. And you have to understand exactly what right and wrong times are to make that deal to the maximum benefit to you and your families. They will also repeatedly contact you. They will, at least unless and until you get an attorney, they may do what feels like harassment. There are certain rules they have to follow, and eventually, if you don't want them to contact, we can talk individually about how to stop that process. But do understand again that they're, like most sales folks, they are going to use time and pressure and try to create a sense of urgency to get you to make a decision that's not necessarily in your best interest. Instead, it's better for you to know and understand exactly when the right times are to make that deal if it's the right thing to do. When they begin contacting you, I want to make sure that you do understand and ask for copies of any documents that they have, anything that they work together, specific drawings, illustrations of the easements, any handouts and materials from the right-of-way agent. Get copies of that. Keep notes. Get materials. Take notes. Get the name, phone number, title, business card of anyone and everyone who you encounter who's connected with the utility company or its subcontractors. Read the documents that they give you, particularly when it comes to anything that they're putting forward as a potential compensation offer. Keep good notes. Gather that information, but don't necessarily give a lot of information. It is really important that you continue to maintain your property, because ultimately the measure and the key question is going to be the compensation that you're entitled to, and that may be based on a date that's far into the future. Let's say one of these projects has a delay for some reason. Maybe some court or some judge determines that the project does have to be paused while other litigation issues are worked out. Sometimes that can cause multi-year delays. If that's the case, you still need to keep your property up, because you still want to preserve its maximum value should you face compensation issues later on in the future. But ultimately, you want to be collecting information, not necessarily volunteering. It is really important that you not settle for their offers. If they come to you and they make an offer, and even if you think that it's good, just take a moment, take some time, and get an evaluation by somebody who's qualified and knowledgeable to deal with this kind of thing. And I emphasize the point of qualified attorney. Not every attorney is well equipped, knowledgeable, experienced enough to be able to give a capable opinion about the litigation issues, the valuation models, and things that a landowner is facing. I don't go to my eye doctor to tell me about my heart, and vice versa. And even like lawyers, mechanics can only be good at so many things. My mechanic only works on certain kind of cars. I respect that expertise and that specialization. The gives that comes through as a byproduct of hard-won experience. And just like that, our law firm and others like us prides ourselves on having the unique and extraordinary narrow skill sets that are required to achieve the best possible outcomes for our clients. A couple of other things to not do is to make sure that you don't discuss issues relating to what you believe the value of your property might be without also talking to a lawyer. I say right here, be aware of the stakeout. One of the things that the agent might say is, okay, well, we're going to offer you $10,000 an acre for your land. And you say, no, that's not good enough. They say, well, what would it take? And you say, well, it'll take 20,000. Don't fall into that trap. Okay. Also, don't call your cousin's former roommate's brother-in-law, who used to be an appraiser, who you think might have some good idea. The expertise and the technical knowledge that's required to do a good litigation quality evaluation and appraisal is not something that's easily found. Knowing exactly who and how to engage the right experts is a big part of understanding how to be successful in creating and getting a proper resolution and full compensation. So you can't just call up your ordinary bank appraiser who, again, issues those 4- and 5-page appraisal reports. That's not going to cut it. You understand that the issues of valuation that that the land agent is trying to get you to come up with a number that they can write down, because they're trying to use that as an anchor point. That's what I mean by a stakeout. They're saying, if I can't get you for 10,000 and you say for 20, then that gives them information and leverage to know exactly what you are willing to settle for. Instead, don't be like the landowner I talked about earlier. Be cautious. You don't have to give information. You can always say, you know what, let me get back to you on that. And then talk to somebody who's actually qualified. Send me a copy of the offer and we could talk about it. And I'll tell you whether or not I think it's a good offer or not. I want to emphasize for a moment that property owners will not lose anything, and it's not going to cost you anything to pick up the phone and call me. Our law firm, we provide free consultations for projects like this. Part of the reason we want and are doing this, engaging with members of the community, is to make sure that you guys are preparing early, and so you can to be aware of these potential pitfalls, so you don't find yourself on the wrong side of a negotiation. As I wrote on the slide here, be careful with any outdated information. Just because your property, may have bought or sold sometime in the last couple of years, that still may be not reflective of current market conditions. And as we've seen in the way that the housing market in particular has changed over the last 3 years, a year or two can make a significant difference in terms of valuation. One of the other things when you talk to an attorney that is really important is that there are certain things that we can discuss privately and confidentially that don't ever have to be disclosed. There's information that I as a lawyer am able to develop that is not considered discoverable. It's not anything that can ever come out in the course of a lawsuit. So that information space and that information protection allows me an opportunity to develop strategic knowledge bases and market conditions understandings that will allow me to advise my clients and members of the community so that they can get the best result. Another thing you don't want to do is, at least not without getting specific legal advice, is consider anything like a rezoning or submitting a development plan. Say you were going to build something on a piece of property that's subject to being imminent condemnation. You want to talk with somebody about that specific and unusual set of circumstances. If there's nothing else that you take away from tonight, I want to make sure that you understand is that you don't have to go through this process alone. The issues in an eminent domain condemnation case probably affect, if not your single biggest investment, then one of certainly a major investment in your family and the nest egg that you have. The other side is the utility companies are supported by an army of lawyers, land agents, site planning professionals. This is what they do all day, every day. There are whole groups of right-of-way agents whose all they do is they work on utility companies, acquisition projects. They do it from places like Florida and Texas and elsewhere throughout the country, and that's what they specialize in. Your responsibility and the best thing that you can do is to build coalitions, develop a network, and work together with other members of your community. Whether that's actively trying to oppose the project in its entirety, that could be part of it. But it's similarly importantly, having kind of a network and a good qualified and competent legal expertise guiding you can be a huge part of a successful resolution. Again, you can evaluate and talk to somebody like me, people who have decades of experience, for free. And one of the things that's really important to understand is that there's a lot of potential poor information out there. I'm not going to give people I'll try to give people general feedback, but the single best thing that I can do, the best conversation I can have, is very specific, and it's talking about an individual landowner and their individual, knowing exactly where, hey, this is how this easement is going to impact this land. And we can talk about in real concrete and specific details, and we can really put some meat on the bone. The other thing to understand is even if I'm giving that individualized advice, individualized consultation and representation to one person, I can take that knowledge, and knowing all the other people in the community that I've talked to, I can leverage that knowledge base to that person's benefit, and vice versa. The more people we have contact with, the more information we have. Say, for example, you as an individual landowner say, well, I haven't heard anything from these land agents. They've been knocking around all my neighbors, but we haven't heard anything. What's going on there? We can help understand, hey, here's what's going on. Here's how things are progressing. Here's maybe when we can reach out, and maybe we can go on the offensive and be proactive if we know that you have particular issues, or maybe time pressures or sensitivities that may be more advantageous to alter the timeline of a project or an acquisition. Ultimately, the key thing is to understand that you don't have to be alone. The one thing that you don't want to do is rush, but also I don't want you to wait. And I know those two things are a little bit contradictory. It's really important that you have the time and to be able to begin to prepare yourself for what is potentially a long and extended process. The earlier that you can be involved, that I can be involved with landowners, the happier they are, the better the results tend to be. It gives me the luxury of time to be able to understand and do a deep dive into how a property is going to be affected, knowing everything that I can about the project, what the issues are, the key issues are within the easement language that I spoke about earlier. And when we represent groups of landowners, which is very common, that again, we can take that collective knowledge and that strength in numbers to create the best possible result. The last thing that I want is to get a call that says, oh, they've just sued me, I've got just a week to respond. That is not the kind of situation that you want to be in, and you don't want to wait till the last minute. Developing your planning, even if you don't fully execute things, begin developing and planning your strategic approach can never happen too soon. I want to leave you tonight with just some real specific and concrete kind of perspectives. They're going to come in and they're going to say to you, again, we need to acquire this portion of your land and we're willing to pay you for it. And here's what we think compensation is. And while these are merely examples that represent kind of two different ends of the spectrum, they do give you an idea and illustrate what can happen. So the question is really, how wrong can these land companies and these land agents be? Sometimes it's only a little. This is a case in Wisconsin that we handled as a law firm involving a utility company where they only offered the property owner $12,500. After doing an assessment, doing our diligence, understanding the nature of the project and the impact to the property, we were able to represent that landowner, and we got them more than twice the amount of money that they were offered. The difference in that additional $16,000 was really meaningful and important to that property owner, and it represented a fair result based on the circumstances that they were facing. Sometimes the land agents, the utility companies, their offers can vary widely, and they can be very, very wrong. Another similar situation where we had a pipeline project in Ohio, the utility company, it was a more substantial taking, more substantial damages relative to the first example I gave you, and they offered our client $60,000, no small sum. We were involved in litigation representing that client, and we got them nearly 10 times what was initially offered. That is an example, again, of what the degree and the range of variation can be, and how off base their evaluation and compensation issues are. That is to say nothing, again, of the non-monetary issues in terms of changing the language and the terms of the easements that we do day in and day out as part of our practice. Now, again, I give you these illustrations not to suggest that every case is going to be worth $500,000. It absolutely isn't. But what you should know and understand is that the pipelines have no interest in trying to pay you money that you're potentially entitled to, and that is meets the legal standards. And so it's really in your best interest to begin developing a plan, as I mentioned earlier, to ready yourself, your family, begin to arm yourself with information so that you can make the best decision possible regarding your property. In order to do that, as I said, I invite you to, if you've received an offer, whether you want to talk about the details of the offer, I would love to hear about it. One of the things that can be helpful to us is sharing information across neighborhood networks, so that I know if landowner A has gotten their offer or hasn't, or I can share that sometimes in a protected way where appropriate with other landowners and say, here, this is what we see coming down the road, and so we can be a source of information distribution within our collective numbers of our clients, and that's an additional part of the service and the reassurance that you can get. Ultimately, you're going to have to make a decision and make important legal decisions facing yourself, your family, and the property that you own in ways that are going to have lasting impacts. And they're going to have lasting impacts in terms of your legal rights, but also in terms of your financial results. You owe it to yourself to go into that process well informed and educated. I hope that you've taken a little bit from tonight's presentation. I invite you to spend as much time as you like on our law firm website. We've got a lot of information there, additional questions that I may not have asked or answered that may come up tonight. And I invite you to spend some time and visit our firm site, get to know more about us, the work that we do, and how we can potentially help you. If you want an individualized consultation, my email is here. It's shiloh@landownerattorneys.com. That's also on the letter, of course, that you received, as well as the phone numbers for our main office, and my direct line is the second number there. I appreciate your time and attention. I'm going to end my screen share. Again, I want to thank you for your the opportunity to be with you tonight, and for the time that you've given me. If you have questions, if you have information that you think others in your community might be helpful to know and understand, if you want more information about other groups that may be helpful, if you are interested in actively opposing the pipeline, or maybe you're on the upside, you're welcome the opportunity for the easement and the financial compensation that it may bring. I invite you to reach out and let us know how we can be of help. I'm here available by telephone and email, and I look forward to hearing from you soon. Best luck and thank you for your attention. Good night.